Hello and welcome. Today's topic is an overview of the trademark application process via the United States Patent and Trademark Office, called the USPTO for short. This podcast is intended to shed light on the steps required by the USPTO so that you can anticipate the road ahead. This is an informational podcast. Please read the full disclaimer posted on the site and listen to the disclaimer at the end of this podcast. If you are a first-time federal trademark applicant, you are in the right place to learn about this important process. If you are already familiar with federal trademark applications, then you may have experienced scenarios described in this podcast, but will also find additional helpful insights that may streamline any future applications you file. Federal trademark application is a process. It takes time and diligent effort. It is not instantaneous and it's not guaranteed. However, in my opinion, federal trademark registration is well worth it for the protection and benefits it provides. So what is the process and what are the challenges? To begin, many first-time trademark applicants wrongly assume that obtaining federal trademark registration is simple and instantaneous. They assume that they will submit an application, pay a fee, and voila, their trademark is registered, sort of like renewing a driver's license. You submit the form for renewal, send in payment, and you receive your renewed driver's license in the mail. However, federal trademark registration is more closely akin to getting your very first driver's license. By that I mean first-time drivers need to complete many steps. One must study for a written exam, get a driving permit, pass the written test, pass the driving test, and if they fail either, take them again. And only after successfully completing all the steps are they granted a license. I share this information because understanding that trademark registration is a process will encourage applicants to be both diligent in their application efforts and patient with the process. Although trademark registration is not instantaneous, I believe that the benefits are well worth the effort. Please listen to the podcast regarding the benefits of trademark registration for more detail on those benefits. So let's jump in. What are the steps in a federal trademark application? The first step is to conduct a trademark search to determine whether your business name is already in use by a similar business. If it is, pick another name and conduct a search until you find a name that is not already in use in a similar business. If you are not yet in business, the intent to use option applies to you. The intent to use topic will be covered in a separate podcast. Once you have cleared a name, you must determine whether you are selling a good or a service and be able to adequately identify and describe the good or service in a manner acceptable to the Trademark Office. The description of your goods or service will then be classified in accordance with the proper class of goods and services defined by the USPTO. Depending on the scope of your business, your trademark may be subject to multiple classes. If so, you may choose which class is most important for your first registration, or alternatively, you can submit and pay for inclusion in more than one class. Let me give you an example of multiple classes. If you are a musical artist that performs live shows, and you also sell CDs of your music online or at shows, then there are two classes that apply. For live shows, Class 41 is the proper class for entertainment services in the nature of live musical performances. And Class 9 is the proper class for goods in the form of sound recordings, phonograph records, and compact discs featuring vocal and musical performances. The next step requires that you then collect and provide evidence of your business endeavors showing your trademark in interstate commerce. Interstate commerce is the legal term for doing business across state lines. With the advent of the internet, many goods and services are, in fact, in interstate commerce. But if, for example, you are a band that has never performed outside your state, or you are a brick and mortar business, say a dry cleaner, that does not do business outside a state, then a state trademark instead of a federal trademark may be the proper option for you. You will also need to provide the date that you first used the name in business anywhere, and the date that you first used the name in interstate commerce. so please review your records carefully to provide accurate dates. You will also need to provide the date you first used the name in business anywhere and the date that you first used the name in interstate commerce, so please review your records carefully to provide accurate dates. Using the music artist example above, the year of first live performances may have only been in one state where the musician lives, but a year later, the music artist books a small tour in different states. In that case, the date of first use anywhere would be, for example, July 4th, 2016, which was the date of the first live show in the artist's home state. And the date of interstate commerce is, for example, May 31st, 2017, the date of the first live show across state lines. If you are not yet in business, the intent to use option applies to you. Intent to use will be covered in a separate podcast. Next, you will need to collect evidence of your use. This evidence is called specimens. The type of specimen you submit is dependent on the good or service you want to register. Using the music artist example, evidence for live performances can include advertisements showing the date and location of live shows, and evidence for sales of music can show the iTunes pages where customers from different states can buy an album or download digital files. Once you have confirmed that your business name is clear, you've identified and described your goods and services and related classes, and have gathered your specimens, either you or your attorney can proceed to completing the online trademark application and pay the non-refundable fee. And then you wait. And then you wait some more. It can take months from the time you submit your application before a USPTO trademark examining attorney assigned to your application will review your documents. The trademark examining attorney's job is to carefully review each and every element of your application. Examining attorneys are more inclined to find problems with an application than to approve it. This is because trademark registration, once obtained, gives you the rights to use that business name to the exclusion of all others in a similar business. So if there is any clarification, additional information, or evidence that the trademark examining attorney wants you to provide, they will issue a request called an office action letter. Common challenges arise when your business name is similar to another business who sells goods or services like yours. Sometimes the issue is with the identification and description of the goods and services. Sometimes there is an issue whether your goods or services conform with the class of goods or services identified. Sometimes additional evidence, called specimens, is requested. You have 6 months to respond to an office action letter. If you do not respond timely and completely to every challenge, your application may be deemed abandoned and you will have to start over again. Even if you timely respond, a further office action letter may be issued by the examining attorney. Importantly, please know that some trademark rules are subjective and open to a difference of opinion. You can submit a fully complete application in your opinion, but the examining attorney thinks differently. There is no guarantee that a trademark examining attorney will view your application the way you do. If an applicant receives an office action letter, I find that it is easier to give the examining attorney the additional clarification, evidence, or other information the examining attorney requires. Using best efforts to comply with the examining attorney's request, even if you disagree with the examining attorney's opinion, tends to be the path of least resistance. You do have the option to avail yourself of the appeal process, but that in and of itself can be expensive and lengthy with no guarantees that the appeal board will agree with you. Once the examining attorney is satisfied and your application is approved, your trademark is then sent out to the public for a 30-day comment period called publication for opposition. Publication for opposition means that public notice is made of your application for trademark for 30 days, where another business has the right to oppose your trademark application. For example, by a company that has been using a trademark similar to yours for similar goods or services, but for whatever reason that company was not discovered during the name search by you or by the USPTO examining attorney. If the 30-day period expires without anyone opposing your mark, then the examining attorney will issue registration on your trademark along with a trademark registration certificate. In my conversations with trademark attorneys at the time of this podcast, the trademark application process is averaging between 8 to 12 months, and much longer depending on the examining attorney assigned to your case, the number of office action letters you must respond to, and any other challenges. So know the road ahead, be prepared, and be patient. To recap, the steps are: 1. Conduct a search to determine whether your business name is already in use by another similar business. 2. Identify and describe your goods or services. 3. Identify your class of goods or services. 4. Determine your first business use anywhere date and your first use in interstate commerce date. 5. Gather your evidence of interstate commerce, called specimens. 6. Complete your application, upload your documents, and pay the non-refundable fee. 7. Respond to any office action letters and satisfy any challenges. 8. Wait out the 30-day publication for opposition period and overcome any opposition. 9. If all is satisfactory, you will receive your registration number and your certificate of federal trademark registration. Your initial trademark registration will need to be renewed between the 5th and 6th year following your registration. Trademark renewal will be covered in a separate podcast. I hope this information on the trademark application process has been helpful, and that now you know the steps involved in general time frame. Knowing these steps will help you prepare and anticipate any issues and be patient and diligent during the process. Federal trademark protection is an important part of a business's intellectual property, and in my experience is worth the effort to receive the benefits of federal trademark protection. In closing, I invite you to consider an excellent resource. The USPTO has created instructional and educational videos on their website regarding many aspects of trademark and the trademark application process. I've included a link on the site. You may also conduct an internet search using the search terms USPTO Trademark Information Network, or go to uspto.gov, and you can also access the Trademark Assistance Center. Please be aware of copycat sites. Look for .gov. And of course, please keep in mind the following disclaimer. This podcast is for informational purposes only. It is general information and may not reflect current law. It is not legal advice nor an offer for legal services. A listener's participation in this podcast does not create an attorney-client relationship nor any form of business relationship. This podcast may be conducted via a public forum. As such, please phrase any comments generally and do not share your personal or confidential information during the podcast or via postings, since your communications will not be confidential or private. I look forward to next time.